Persuasive writing is at the heart of what we do as litigators. If you are a litigator, your professional mission is to persuade. That is why your clients hire you. That is why they pay you. For most litigators, certainly most civil litigators, most of our persuasion is written. Most cases don't ever get to trial. They're resolved by settlement or by rulings on motions. And even cases that go to trial are often heavily influenced by pretrial rulings. After a verdict, victory can be snatched away or disaster averted by a pretrial motion or through an appeal. Writing persuasively, therefore, is the single most important skill that a litigator must have to work effectively. It is not optional. I am William O'Brien, and since the 1980s, I've been struggling to persuade judges to rule on behalf of my clients in federal and state trial and appeal courts around the country. I'm basing this presentation not only on my own long experience about what works or doesn't work, and my positive and negative observations of the work of numerous other lawyers over the years, but also extensive study and reflection about what judges, lawyers, writers, psychologists, and philosophers have written about writing and persuasion. Since the 1990s, I've specifically concentrated on intellectual property cases, but the same basic principles and techniques apply to any litigation. For purposes of this presentation, I'll be focusing mostly on formal persuasive writing, such as appeal briefs or motions and supporting memoranda, documents that would be submitted to a court. But the same principles apply to any document written to persuade. It could be a mediation brief, or a letter trying to persuade a client to take or not take a particular course of action. It could even be an internal memo or email within a law firm. Writing isn't just a physical thing like a brief or a declaration. It's a process. The process you follow will largely determine the result that you get. So I'll be talking quite a bit about the writing process. And I'll start with the first step, which is usually the most important step. First and foremost, to write well, you have to think well. You have to think clearly. You have to think thoroughly. And you have to think from the point of view of the person you are trying to persuade. Now, it may seem obvious or even obnoxious to tell people that they have to think about their legal writing, but I emphasize this step for a reason. In my experience, we often fail to do enough clear and deep thinking before we start drafting a court filing or other persuasive document. Most of us have a tendency to hurry up and start writing or start researching without a clear focus on what we want to look for and what we want to say. Even more dangerously, we may just grab a prior document of a generally similar nature and start editing it. It's often best to start with what you already know about a case and a situation and think about that carefully before you go casting about for more information. Especially if you're already working on the case, but even possibly if you haven't been. You already know more than you think. Usually, you already know most of what you're going to need to know from already working on the case or from reading the basic documents in the file, as well as any motion or brief to which you'll be responding. Further, the things that you already know are usually the most fundamental and important things. Digest the fundamentals that you already know before you distract yourself by digging into the weeds in search of more detailed information. Make a list right at the outset of the points you want to make. Points about the law, points about the facts, points about your client and the opponent and the case. Of course, you should expect to add to, delete from, and refine these points as you do the work necessary to transform them into a document worthy to be filed. But an initial list will get you started and focus your efforts, making them more effective and efficient. And when you look back at the end of the project, you may be surprised by how extensively you were able to identify the important points right at the outset. When you're planning your work at the beginning of a writing project, Be sure to consider all the important players and components in the situation. These include you and your colleagues, a goal, someone that you're trying to persuade, facts, and law. Consider at the outset your own situation and your team for the project. Know yourself and plan accordingly. Realistically assess your experience and skills, your existing factual and legal knowledge, and your time constraints. Build in time for multiple rounds of review and revision. Check on the schedules of anyone who will need to review or approve the documents or to provide support. Arrange at a minimum to have at least one person review your draft, because once you've gone to all the work to prepare it, your objectivity will be severely challenged. You'll benefit from a fresh perspective. And if you're going to need other help, try to arrange it early rather than at the last minute. Think carefully about your goals in the case. Not only your immediate goal in filing a particular document, but your ultimate goals and how you intend to get there. As a practical matter, we're always operating with a range of goals of varying importance and longevity, ranging from getting along with our colleagues to pleasing the client to just meeting the deadline. But always remember that your ultimate goal is to win the case for your client. Don't do anything along the way that will undermine your ultimate case themes and objectives. Persuasion is all about persuading a person or a group of people. So it all depends on the judge or other person or persons you're trying to persuade. Look at everything from the point of view of that person or persons. Learn everything that you can about your judge, about the court, and understand how judges make decisions. So what are some of the key factors in a typical judge's decision-making process? Time pressure is one of the key ones. You're going to have a very limited amount of time and attention typically on whatever matter you're bringing before the judge. Law clerks do a lot of the work in many courts. They're going to heavily influence the outcome in a number of situations. The judge's past rulings may provide all kinds of critical information about your prospects and how to approach a matter. Habits and shortcuts, both of your particular judge and judges in general. Their tendency to use pattern recognition, to jump forward to a likely conclusion based on how this situation looks and feels compared to what they've experienced in the past. So what is a judge likely to think about and be influenced by? He or she's likely to ask, well, what does common sense tell me about this situation? What have I or judges I respect or am bound to follow done before? What do the rules or precedents require? What's fair? What will be easiest? What will be fastest? What will get rid of this case? Who's the good guy? What message do I want to send? After your initial planning and brainstorming, the next stage of your writing project is to gather the facts and the law that you'll need. Fact gathering is both the most important and the most neglected aspect of preparing persuasive legal documents. The facts are the one thing the court can't look up itself. Unlike the law, they aren't written down in publicly available documents. They may not be written anywhere. They may only be in people's heads. The clients who may know the facts usually don't fully understand what's important. But even though fact development is where the court is likely to need the most help and where lawyers may be able to add the most value, the facts tend to be underdeveloped in legal writing. Sometimes this is because of failure to think ahead, or lack of creativity, or just reluctance to go out of the office, meet people, inspect places and things, take photos. It can also result from the way in which responsibilities are allocated within many law firms, where you may have a junior person assigned to prepare the first draft of a document. Meanwhile, a senior person is handling most of the client contact. That can lead to a disconnect. In any case, anytime you embark on an important writing project that depends on evidence, don't be satisfied with what you're handed or what you already have on hand. Ask yourself what evidence might exist to support your side's version of the critical facts besides what you already have. What are the ways in which, in the time available, you can seek out some or all of that information and put it into a form that can be submitted to the court? Look most of all for telling details, examples, and illustrations. There's a famous saying, show, don't tell. Actually, you should do both, but the showing is the more important and persuasive part. Also, don't forget the things that are important because they didn't happen or they don't exist in the record. Like Sherlock Holmes's famous dog that didn't bark in the night, that can be the most telling evidence. Ask yourself, if the other side's version of the facts is correct, what evidence should exist but doesn't? Researching the law is one of the most familiar and comfortable areas for most lawyers, and especially junior lawyers. But here again, I think that there is a failure sometimes to approach the problem creatively or from the right perspective. Reciting legal rules is not enough, no matter what court and how authoritative a source has stated them. Fundamentally, the law isn't what judges say, it's what they do. And it's what they do in a particular context. You need to analyze key cases in detail. What happened in the particular case? Why? And in what procedural context? Compare the case to yours. Ideally, you want a precedent where the outcome was the one you want, but on facts even weaker than the ones you can show. And the ruling should happen in an equivalent procedural context to the context you're in, or one that was less favorable to the result you're seeking. Compare your cases with your opponent's cases. How do the facts compare and the procedural posture? What were the practical and policy considerations underlying the decisions? Which case is better reasoned? Which case is more like yours? To use law effectively, you need to pay attention to the hierarchy of authority. At the highest level, we have the Constitution, which usually overrules everything else, but is subject to a very wide amount of interpretation. Then statutes, court rules, court decisions, treatises and articles way under that. Court decisions vary greatly in their persuasiveness. Higher courts may have made decisions that are binding. En banc decisions may be even more authoritative. Decisions may be precedential or unpublished. And these days you'll be coming across a lot of unpublished decisions which you need to recognize and consider right at the outset. Courts in the same circuit may be more authoritative than courts in other circuits. Even within the same circuit or the same district court opinions aren't binding on other district judges. Some district judges may be strongly inclined to follow the other district judges in their district. Others may not care very much. And some judges may have either high or low opinions of some of their colleagues. Once you've gathered the facts and law, then you need to think further about what to say based on the perspective they've provided and the further time you've had to think about the document you'll be writing. How do you decide what to say? It all falls into three categories. There's what the court needs to know to decide the issues that you or your opponent are putting before it. There's what the court will likely want to know in looking at those issues. And there's what is likely to persuade the court to decide them in your favor. That's it. Then you're done. Now, obviously, these three categories overlap. What the court needs to know is fundamentally pretty obvious. First, you need to be very clear about exactly what you want the court to do. You need to clearly, logically, and persuasively present the facts and the law supporting that result, and you need to explain why that is the correct result based on the facts and law. You also need to include any information required by court rules. But besides what the court needs to know, there's also what the court wants to know. These are also things that may help persuade the court. People like context rather than being presented with specific issues in isolation. And judges are people. They like to know who they're dealing with, what these people are trying to accomplish, not just at a particular moment, but more generally. Why those people are in their court and where it's all likely to lead. So, having told the court what it needs to know and what it wants to know, as best you can figure that out, what can you say that will persuade the court to rule in your favor? Well, at the most fundamental level, the elements of persuasion are not new and haven't changed very much. 3,200 years ago, Aristotle identified three of them, and they still apply today. Of course, one of the things he included was logos, or reason, the origin of our word logic. That includes things like statutes and rules, precedents, burdens of proof, standards of review, weighing evidence, public policy, and practical consequences. But logos was not the only element that Aristotle found to be crucial for persuasion, or even the most important. Aristotle started with what he called ethos, what we might call character or reputation. He thought that ethos should come first, because why should anyone listen to somebody who didn't have good ethos, wasn't credible? So ethos would include your credibility and your character and your reputation, those of your firm and those of your client. Aristotle also emphasized pathos, or emotion, because before someone will take action in your favor, the person has to be motivated to act. Pathos is the root of our word pathetic, but it doesn't just refer to pity or sympathy. It could be anger, distress, frustration, or boredom. Imagine someone comes up to you and asks you to do something for him. Are you more likely to do it if you know him? If you like him? How about if he's previously done something for you? Or, on the other hand, what if he's irritated you in the past? He's made your work or your life more difficult. Of course, those things influence the frame of mind with which you would consider a request. Why would you think that judges are any different? By the way, this doesn't mean you can't win a case on an opponent's home turf. I've done that plenty of times. But you need to look for opportunities to introduce yourself and your client to the court. And you want to show yourselves to be the kind of people that a judge will want to help. To be sure, it's a lot more difficult to demonstrate a favorable ethos in modern litigation than it was in ancient times. Now we're supposed to pretend that everyone cares only about logos, the facts and the law. An ancient orator could mount the podium and immediately launch into recounting his past achievements and maybe even lift his toga to show the scars he had received in defense of the motherland. Well, we can't do that, but building ethos can still be done. And most important, you can work hard to avoid developing a negative ethos in the court. What do? Read and follow local rules and standing orders. Be accurate in everything that you say. Show that you care about the court's positions and concerns. Be interesting, but not in a bad way. Don't create unnecessary problems and emergencies. Try to avoid coming across as seeking try to avoid coming across as seeking to take up the court's time with trivia or with procedural gambits where it looks like you're just trying to delay things or create a distraction. Don't attack the opposing party in counsel. Don't waste the court's time. When we turn to consider pathos or emotion, well, what types of things have emotional appeal to a typical judge or a typical human being? Well, we all like to see the guilty punished, the innocent vindicated, prevent unfair advantage. Judges, like lawyers, I suppose, can also be people with healthy egos that can be appealed to or that can provide an obstacle in some situations. How do you work with the emotion of a case and take advantage of it? Well, connect specific issues to the overall themes of your case. Humanize your client and witnesses. Show how the case looks from your client's point of view. Provide relevant facts that explain your client's conduct and cast a dim light on your opponent's conduct. But try not to make your reader conscious that you're playing for sympathy. It loses most of its effect as soon as the reader stops and thinks, oh, this is here to try to prejudice me in favor of ruling for this side. Experts on psychology and persuasion seem to all agree that a key aspect of a persuasive document or a persuasive argument is telling a story. For time immemorial, people have cared about stories and been influenced by stories. According to Maxwell and Dickman's book, The Elements of Persuasion, a story typically has 5 basic elements. There's passion, something to be cared about. There's a hero, an antagonist, awareness that comes to the hero, and a transformation as a result. Now, your particular story may be a big story that has to do with the entire case and the fate of people and businesses. Or it might be a small story, a discovery dispute. But the same elements can apply regardless. You can tell a story of how you're conscientiously trying to prepare your case for trial, believing that your client should be vindicated, but needing the information to prove your case. You've tried to get the information from your opponent following the proper discovery rules. In this story, you're the hero. The antagonists are the opposing attorneys who are objecting without merit. They're asserting boilerplate and evading providing answers and information that you're entitled to. You become aware of this problem and you try to solve it. You write to them, you talk to them, you explain why you need the information, you explain why their objections are badly taken, unfounded. Unfortunately, it becomes evident with time running out in the case that you have to get the help of the court. And it's even better if you can put this small story in the context of a bigger story, where the kind of conduct that you're faced with in trying to obtain this discovery is typical of the whole approach that your opponent has been taking. Not throwing in gratuitous and irrelevant personal attacks, but trying to develop a theme that this is an ongoing problem that the court now needs to address. The story could even extend to the merits of the case, where the conduct of the party in litigation fits with the lack of merit of the litigation. They've never been able to identify the support for their case. They weren't able to identify it at the outset of the case, and now the same conduct is continuing in discovery. So now you've brainstormed, you've collected facts, you've researched law, you've decided what story you plan to tell. It's time to write it all down. And I suggest that you write it on a clean sheet of paper or a clean computer screen, to be more realistic. Use previous documents, but use them sparingly. Get ideas. But you're rarely, if ever, going to have two situations that are so identical that it makes sense to shoehorn one into the contours of the document that was created for a different case or a different situation. What you'll find is no matter how extensively you revise the previous document, it's still going to bear traces of a different context. There are going to be missed opportunities to take the maximum advantage of your particular situation. Also, from experience, if you use previous documents, no matter how reputable the person or firm that created them, check everything carefully. It's amazing how errors can slip into documents and go undetected. And a cautionary tale for all of us in creating our own documents. Having written down all the points you're going to make, put them in order. Decide the order of the sections of your document, which will sometimes be prescribed in part by local rule, and decide the order in which you're going to make your arguments. Typically, in an opening document, like a opening appellate brief or a memorandum in support of a motion, you're going to want to start with your strongest argument. unless there's some logical reason or some preliminary matter that's going to be distracting unless you deal with it, which is rarely the case, go right to your strongest point. And then you also want to try to close on a strong note. In between those two points, strong points, you should typically take the opportunity to refute arguments that you anticipate coming from the other side or objections that you anticipate the court itself may think of. Now, you don't want to go overboard. You don't want to think of and refute subtle arguments that may never occur to your opponent. But as a general proposition, I don't agree that the most persuasive thing to do is to wait for your opponent to make its arguments and then come back in a reply document, even assuming that you have one. If you can be sure that a point is going to be argued, why wouldn't you want to take the lead in shaping the court's thinking about that point? It's an opportunity that's open and should usually be taken. On the responsive side, if you are filing an opposition brief on behalf of an appellee, or you're opposing a motion, then you need to think carefully about what will be most effective from the point of view of your audience. Aristotle said, and the late Justice Scalia and Brian Gardner in their book on legal persuasion agree, that typically you may want to, in response, answer the strongest arguments made by the other side. And the reasoning is that it's going to be hard for the court to concentrate on your points and look at the case from your perspective with the movant or appellant's arguments still fresh in their mind and no rebuttal. So what you want to try to do is shoot down your opponent's way of looking at things and then follow up with your approach. So don't limit yourself to just responding point by point to your opponent. Tell your story your way. Formulate your arguments your way, but typically do that after you clear away the brush of your opponent's arguments. Now, on reply, you're supposed to be limited to responding to your opponent's arguments. However, you want to provide context for that for several reasons. These include that some judges and clerks go ahead and start with the reply brief and then work backwards. And if they do, you want them to fully understand the points that are being discussed from your perspective. The other thing that I think is very effective and underused is to use the reply brief as a tool for recapping for the court where things stand now that you made your opening arguments and the opponent has responded. Among the most important points for you to make in a reply may be the points that your opponent has expressly or more often impliedly conceded. And where your opponent has argued against something, I think that you typically still want to succinctly recap what the point was in your words, not your opponent's words, in order to put your reply in the appropriate context and the most persuasive context for your side. Having prepared a draft in which you set forth your arguments in the order in which you think they will be most persuasive, you need to review the draft and identify and fill missing pieces. There are going to be facts, details, citations, specific legal points that you may have overlooked, and that reading the draft in context, or reading everything in context as part of a draft, will help you identify. So go through and fill those in. Then you need to connect everything together. Write an introduction, write linkages between the various, and transitions between the various portions of the document. Your goal is to grab the judge's attention, try to get the judge thinking in your favor, and then carry the judge along to your conclusion. So try to start your document in a way that will grab attention. Look for a way to make your document stand out from the beginning, a way to be interesting. Now, don't get too cute, don't be annoying, and don't say anything that's contrary to your goals or themes for the case. If one of your themes is that this is a boring case, just like a large number of previous cases that this judge has seen, and that he or she should dispose of this case in the same way that he or she always deals with these cases, then you don't want to say anything to suggest that your case is actually unique. But that doesn't mean that your document can't be a little different. Is there something catchy or charming that you can say in making the point that this case is like all those others? Sometimes people start with quotations. They don't have to be quotations from cases or from legal writing of any kind. They can be from famous essays, novels, movies, quotations from Steve Martin or Yogi Berra. But consider your audience and go a little light on trendy pop culture references with most judges. Don't use a quotation that your judge won't get, or quote a person that he or she may dislike. If you have a really compelling photo, graph, or other image, consider putting that near the beginning of your document. Whatever you do or don't do to grab attention, always keep in mind that your reader's attention is likely to be at its highest at the beginning of the document, when the reader's wondering, well, what is all this about? Don't squander that initial attention by starting with boilerplate irrelevancies or statements of the obvious. Now, having gotten, you hope, the attention and favorable consideration of the judge, don't lose it. Try to create a flow towards your favorite conclusion. What are some of the tools you can use to do that? Well, first and foremost, provide information in an order that will make sense to the reader, given what the reader already knows and doesn't know. Use argumentative or explanatory section titles rather than just statements like argument or standard of review. Explain how your points relate to one another. Are there alternative arguments for the same conclusion? Is one a premise for the other? Use topic sentences. Having created a flow, you need to maintain the flow. which is no easy task when faced with a plethora of facts, legal issues, and procedural requirements. Make sure the reader understands why you're making each point. Prove each point as you go along, and anticipate questions and counter-arguments. Never leave the reader in doubt about why you're telling him or her this or that. The reader shouldn't have to wonder, where is this going? Is this detail important? Once you have a complete draft, rewrite, rewrite, rewrite. I don't know who first said it, but the saying that all good writing is rewriting is emphatically true. Everything's on the table as you go through the drafts over and over again. Move parts around, fill gaps, add titles and transitions, add supporting details, delete unnecessary portions, reconsider weak arguments, tighten and clarify. Also take the opportunity to get feedback. Feedback on your writing is a mixed blessing and curse. If you're inclined to have any pride of authorship, it can be very painful. But look at it as an opportunity to get another perspective. And if somebody criticizes your document or makes suggestions that you don't agree with, don't just focus on shooting them down. There can still be useful information there. Try to look behind the edit to its motivation. Sometimes, if somebody suggests that you add a legal or factual point, you're more knowledgeable about the details. You may understand that what they want to say is actually wrong. But ask yourself, well, why do they want to add that? What are they responding to? And is there another way that you can accomplish that effect that is legally and factually accurate? Sometimes the best comments are the vaguest because they just provide you with some inspiration and motivation to do some more thinking and working on your own. I can remember submitting a brief to a senior partner who said to me, well, this is pretty good. Just make it sing. Well, what did that mean? That's what I had to decide, and it was a useful process to go through. Try to circulate drafts early so that you have plenty of time to address points that people make. So a critical aspect of creating and maintaining a flow towards your desired conclusion is to eliminate distractions. Get rid of loser arguments. And I know that's very painful. It's difficult. Sometimes you just can't figure out which arguments are most likely to appeal to your particular judge. There's a random aspect. At the same time, if you're making a large number of arguments, they're going to drown each other out. You may just have to take the risk, use your best judgment as to what are the weaker points, and let them go. It's another reason to try to circulate your drafts early so that you don't have people, rebelling against those decisions at the last minute. Eliminate snark and personal attack. Your clients may love it. Judges hate it. eliminate legal jargon and cliches. Eliminate throat clearing, filler. One of the major tasks in any kind of writing is to go through and eliminate unnecessary words. Make multiple passes to tighten the language, eliminate unnecessary statements and passages. Where the statements are necessary, tighten them up, reduce the number of words used, make them clearer and more forceful. Now, it's very common when you look at legal documents to see a gigantic amount of filler and boilerplate. Legal writing, unfortunately, can be an extreme example of a problem in writing generally. The writer William Zinsser has said, "Clutter is the disease of American writing. We're a society strangling in unnecessary words, circular constructions, pompous frills, and meaningless jargon." And who is possibly more guilty of that than anyone else? I fear it may be lawyers. A typical legal document is likely to start with some kind of a lengthy title, followed by useless filler in which no new information is presented of any significance. Now comes plaintiff so-and-so, through his counsel so-and-so, and moves this honorable court for such and such. Why? Is this required by court rules? Rarely, if ever. Instead, Professor Wayne Schiess blames inertia, fear, and a misguided sense of professionalism. He says, far too many lawyers believe that an over-formal tone, archaic usage, and traditional formatting are hallmarks of a professional. This is no longer true if it ever was. In fact, the trend is the opposite. The more formal, legalistic, and archaic the document, the more likely the audience is to perceive the writer as inexperienced, ignorant, or provincial. Now, please don't try to defend this kind of writing by arguing that it's what judges want. That claim has been tested and disproved a long time ago. Professor Schiess cites a 1987 survey in which judges chose between two introductions to a complaint. Now comes the above-named John Smith, plaintiff herein, by and through Darrow and Holmes, his attorneys of record, and shows unto this honorable court as follows, versus, for his complaint, plaintiff says. Now, I personally would probably use an even briefer phrase and just say, plaintiff's name alleges. Michigan judges preferred the second, shorter version by 84% to 16%. 88% of Florida judges preferred the simpler version. Judges in Louisiana and Texas weren't as forward-looking. Only 75% of them preferred the simpler version. But of course, all of these percentages would be even higher today. So trash the wordy anachronisms and get to the point. As a general principle of writing, not limited to legal writing, if you want to tighten your phrasing and eliminate unnecessary words, one of the best tools is what I'm going to call, creating a little jargon of my own, denounification. Unwieldy and unnecessary worded phrases often originate when you use a noun for something that you should use a verb to do. So you perform an analysis when you should just analyze. File a motion for dismissal instead of move to dismiss. Say that a defendant committed willful infringement instead of the defendant willfully infringed. By just changing these noun-based phrases into simple noun-verb clauses, you make your writing clearer, more interesting, and more succinct. There's also widespread use of what I'll call compound constructions, like saying in the event that instead of if, with reference to or with regard to instead of just regarding, or better yet, about. Lawyers love to say prior to or subsequent to instead of just before or after. Now, don't worry too much about these noun-based and compound constructions creeping into your writing as you create your early drafts. That happens to the best of us. But when you go through and edit, you need to get rid of them. Your draft will benefit enormously. As a general proposition, use plain English. You're trying to persuade a judge who almost invariably has English as his or her native language. Now, true, the judge has suffered through years of tedious legal jargon in law school, and even more so in filings that he or she has to review on the bench. But that doesn't mean the judge likes it. It doesn't mean that the judge finds it persuasive. What's going to be more moving to a typical judge? A word or phrase that he or she has heard since infancy, cradled in mother's arms, or a word or phrase that he or she had never heard until the first year of law school? Most legal jargon is completely unnecessary. Now, that doesn't mean there aren't terms of art. If you want to talk about promissory estoppel or patent invalidity, you need to use those terms for clarity. But a lot of what is consuming space in legal writing is absolutely unnecessary and off-putting. At the very least, it prevents you from using a more compelling and more succinct formulation. So get rid of hereby. You don't need it. You don't need hereinafter. You don't need wherefore. You can state the relief that you're requesting in your complaint without starting with wherefore, and you'll be equally entitled to the relief as using wherefore. Nobody says pursuant in real life, and I try to not say it in my legal writing either. Say under instead of pursuant to. Every day, lawyers all over this country are writing whereas over and over again at the beginning of hundreds, if not thousands, of stipulations and contracts. Can you imagine anything more useless and tedious than reading this obsolescent word, which nobody uses in ordinary speech, 10, 15, or even 20 times in a row? And it's pointless. If you want to write a fact, just write it. Inter alia is almost always unnecessary. Rarely is it the case that you'll be understood to be saying that this is the only thing of a certain type, unless you say inter alia. Legal cliches are probably too many to number. I'll mention a few. One is egregious. It's an interesting word. If you look at its roots, it comes from like outside of the herd. It derives from the Latin word egregious, meaning distinguished or eminent. So in its earliest English uses, egregious was a compliment. Now it's generally used as a way of suggesting that something was unusually horrid in some way. Well, there are plenty of words to describe bad things. Just use an appropriate, specific, and compelling word instead of a legal cliche. Disingenuous is another. The first time it was used, it probably seemed clever. Ingenuous means with a childlike innocence. So saying disingenuous was a subtle way of suggesting that somebody was was being tricky, if not deceitful. But with almost 4.5 million hits on Google, it's been used enough, it needs to be retired. Less than candid is another cliched expression. And it starts to get into snark and personal attacks, as does disingenuous. If your opponent has said something that's inaccurate, just say so. If your opponent has said something that's incomplete or left out a fact, just say so. You don't need to attack them. Just point out that something is wrong or missing. An important aspect of clear and compelling writing is your choice of words. One of the things that makes English a great language is that we have such a large vocabulary, and one of the reasons for that is that English is basically French overlaid on a Germanic language, which, as I understand it, it has as its closest modern analog probably Danish. So we have many parallel or alternative words. Often there's a kind of short, strong-sounding Germanic word, and then relatedly a more elegant or sophisticated, usually longer Latinate word. And as babies, we typically use or start off learning the shorter Germanic words. And in an emergency or moved by strong emotion, we tend to use the short Germanic words. They tend to be more emotionally weighty, whereas the Latinate words tend to leave us a little bit more emotionally detached. So for reasons of clarity and emotional impact, your default should be go for the simple, short Germanic words. Try to be a little bit interesting in your choice of words. If you can say something a little differently from what the judge always hears, that's all to the good, as long as it's not distracting or confusing. Try to avoid what William Fowler called elegant variation, where you call the same things by a lot of different words just for the sake of relieving the tedium. Use consistent words for the same and similar things. it's clearer, and it avoids confusion. Try to avoid or minimize abbreviations and acronyms. There are some things where the abbreviation and acronym is so overwhelmingly well known that you, of course, are going to use it. The FBI, NASA. Other than things like that, why not give things a name, which makes them more relatable? In patent cases, it's common to refer to the USPTO. Now, a judge knows that means United States Patent and Trademark Office. To me, it's more relatable to say the Patent Office, or in a trademark case, the Trademark Office. It's not the technical term for the office, but it is obvious what it means, and to me, it's more relatable. Try to use an approachable name for your client. Unless your client's initials are well known, like IBM, try to avoid using initials to refer to your client. At the same time, while you're trying to be a little creative and use the strong Germanic words, be dignified. Don't use anything that is silly or obviously prejudicial to the other side in terms of how you label entities. Try to avoid foreign expressions, even if they're well known. Within the last 3 weeks, I reviewed a document that a 1,000-lawyer firm was about to file and had to point out to them that they had used IE when they should have used EG. So IE stands for id est, which means that is. In English, in other words. So why not just say that? On the other hand, EG stands for exempli gratio, which means to give an example. So why not just say, for example? Even if your reader knows what those mean and doesn't get them confused, which I've seen a lot of lawyers in courts do, by the way, there's less mental effort involved in just reading, for example, rather than reading EG and translating it, which is the mental process that even people who are familiar with EG are going to go through. As part of your process of revision, I would urge you to try to do what could be called bulletproofing your writing. In other words, protect it against not only attacks, but doubt, questions. If we go back to the metaphor of a flow, the powerful current by which you're trying to carry the judge to your desired conclusion, you want to avoid turbulence. Or to switch metaphors, you want to reduce friction as the judge glides along to your chosen destination. So anticipate your reader's questions and objections. As you go through reading and improving your drafts, when you make a statement, ask yourself, why? Why is that true? How do we know that's true? What's your proof? So what? What's the importance of that? Why do I care? Try to anticipate those questions and objections and answer them where they will first occur. Otherwise, the doubt and distraction is building up. As you're trying to move the judge to your conclusion, the resistance is building. It's the equivalent of an oral argument never telling a judge, oh, I'll come to that point you asked about later. The judge is encountering the doubt now. So you have to answer the question now and try to resolve it. It's a harder question in writing because the judge doesn't get to talk to you as he's reading the brief. But try to think about, from the perspective of a reader, what questions are going to arise where. A key concept I'd like to emphasize when it comes to preparing persuasive documents, especially in today's media-intensive world, is the use of graphics. They are badly underused. I've even read appellate briefs in highly technical patent cases where there wasn't a single drawing or illustration. So graphics are a wonderful tool to establish facts, to explain technology, to support analogies, to summarize arguments. And if you're filing a document subject to a word limit, they don't count. Although if you're getting really close to the word limit, you do need to worry about the words that are contained in your captions and any call-outs that you have within the graphics, which may not be automatically picked up by your word processing software. So keep an eye on that. So graphics can be things in the record. They can be evidence, or they can just illustrate an argument. They give you a lot of room for creativity. For example, just to pick one of many cases of explaining a technology, I had a case some years ago that involved refrigerator shelves that used what was called a hydrophobic barrier. So there was a strip of chemical around the edges of the shelf that actually would contain fluid. So the fluid, say you spilled a Coke can on the shelf, the fluid would spill out, it would spread out to the barrier, and then stop. It's pretty amazing thing to see. It's one thing to talk about it. It's another to put photos in front of the court showing what it looks like. And if you're in a dispute about whether that should be patentable, it certainly helps to promote the idea that this is a remarkable thing that might be entitled to some protection. So I often use graphics to illustrate concepts going outside of the record. For example, I had a case that involved how to interpret the word cap in a patent. So we showed the court examples of things that are called caps and other things that are not called caps. And we explained what the common element was in calling something a cap and why the accused feature of our particular client's product didn't qualify as a cap, as one would ordinarily understand that language. I had another case that involved how to interpret the word ledge in a patent. And the plaintiff who was asserting the patent was asserting that that the top of a very thin, I would say fin-like structure in my client's product was a ledge. So how do you succinctly and forcibly make the point that the surface of a thin structure like that isn't a ledge? So I gave a couple of examples of ledges, shelf-like horizontal surfaces. And then I tried to figure out how to graphically convey how narrow my client's vertical surface was. And there wasn't a good illustration in the record, but the record contained the dimensions. So what I did was I just used word graphics to create a vertical line that corresponded in size to the cross section of the structure as shown in the specifications, and played a lot with a ruler and different degrees of magnification to get it to print in the brief to the exact dimensions. And it just looked like a very thin line, and there's no way that that the tip of that line could be considered, a shelf. Graphics can also be used to explain and summarize arguments about a physical item, like a list of all the reasons why a certain product doesn't infringe a patent, pointing to the various corresponding features. Another thing to take advantage of and to think about in the process of preparing, and especially in revising and finalizing your persuasive document, is considerations about the physical appearance of the document with regard to fonts and the document design. This is an area that's been receiving a lot of additional attention, and I think is an area we should all be focusing on more. So try to make your documents look good. Try to make them, above all, easy to read. And there are a number of things that are conventionally done in legal documents that have the opposite effect. Underlined text is hard to read, so try to avoid underlining. All caps are hard to read. Try to avoid those. The reason for that, by the way, is that one of the cues that you use in reading is the variation in heights of the letters as your eye runs along a line of text. With all caps, they're all the same height, so it's harder to read. Instead of using all caps, why not use a bigger font or contrasting font? As long as it's permitted by local rules, you could use a serif font for your main text and a non-serif font for your titles. What about, if there's no rule against it, using color for your titles? Left justification is easier to read than full justification. Again, there's something about the ragged right edge of the text that your brain actually uses to help it move through a page. You can consider using lines and boxes to separate text sections and titles. Make sure what you're doing will reproduce well, both in terms of a PDF if you're doing electronic filing and if it's printed out later, because many judges still like to look at the paper version. So let me just quickly run through the typical sections of a brief and briefly talk about them. The first substantive section of a brief or a memorandum of points and authorities is typically and should typically be an introduction. The introduction is a place where you foreshadow what you're going to be saying, and you weave together the facts, law, and arguments in a persuasive way. Get right to the point in the introduction. Don't waste time on procedural background that isn't important to the specific issues. Say what you want and why you should get it. Try to make it interesting. Address all the major issues and summarize your main positions on each issue. I like to provide cross-references to the corresponding sections of the argument. So if a judge says, oh, I'm interested in that point, he can immediately skip to the place where I support it. I try to make the judge think, if these things in the introduction are true, then this side deserves to win. So the introduction is, in a sense, just setting forth the criteria for the winning argument to follow. So typically you're going to have a statement of facts. You need to think about how to organize that in a persuasive way. That may be chronological, or that should be your default usually, but there may be other ways to organize it. Don't expressly argue in the facts section. Instead, show the significance of facts using topical headings, topic sentences, order of presentation, and juxtaposition. Where, for example, if somebody on the other side is arguing a particular point, you don't say, well, that's not true for these reasons, but you do say, here, however, is this evidence, and you make it clear by juxtaposition that this evidence refutes the point the other side is making. You can use section titles to make it very clear what points of particular facts are going to. Don't have the reader reading facts and not knowing if or why they're important. Don't hide from bad facts. If there are bad facts, they're going to come out. You want to frame them your way and have as much control over how the judge thinks about them. Put them in perspective, to put before the court any counter evidence. Don't let the judge find out about bad facts from the other side first if you have the first word. And if you are the one going second, try to address all the bad facts to the extent you can, either with counter evidence or in your argument section explaining why they're not dispositive. If you ignore them, the court is likely to notice and to treat it as a concession. So as with the dog who didn't bark in the night, don't forget the facts that are important because they didn't happen or they aren't in the record. And note the relevant procedural history, but only if it's really relevant to the points at issue. For example, if you're moving for summary judgment based on lack of proof of a certain point, note your request for discovery of any evidence on that point, your opponent's failure to provide any such evidence, and any follow-up attempts you made to obtain it. You may, in fact, need to submit a declaration to show those things. One of the most important or common mistakes that people make in a statement of facts is providing too much information that doesn't make any difference. Always think about whether a point needs to be in there, and if so, at what level of detail. If the date when something happened isn't important, don't put the date in. If the only thing that is important is the sequence, just note the sequence of events without dates, or say the year if that's important, or the month, but give as little information as is really necessary so that you're not wasting the court's time and creating confusion about what it's important to remember and what it's not important to remember. So what would typically be the argument section of a brief has really been the focus of most of what I've been talking about. I don't think I need to add a lot to that, but I do want to make it clear that when I talk about an argument section, that doesn't mean that it needs to be called argument. Sometimes court rules make that necessary or appropriate, but whenever possible, use persuasive section titles for your argument, not things like argument, analysis, discussion, or standard of review. You can simply say, for example, what the standard of review is, or a capsule statement of what your point is that you're trying to make in your argument. So ideally, you want to have an argument where if you were to just read the titles of the sections, it would tell a persuasive story about why you should win the case. Another thing about argument is the use of quotations. They're a powerful tool, but they're often overused or misused. Don't confine them to parentheticals where you basically paraphrase a rule, for example, then you cite a case, and then you have a parenthetical quotation. Well, if the parenthetical quotation supports your point or makes your point, why not just lead with that and then cite the case? You should feel free to heavily truncate quotations and use bracketed changes to fit your context, just making sure that it's not misleading and that you clearly signal what you're doing. Use block quotations, but use them sparingly. Research shows that readers, when they confront a block quotation, tend to skip over it. So what you should do is say what the point is of the quotation that you're about to quote, and then work the quotation into your main body unless it's a special case where this is, like, for example, a key point and you want to really eliminate doubt about what the court was saying, or there's some kind of an interesting flavor or context. For example, a witness's key deposition admissions, you might want to actually quote the questions and answers to make it clear this wasn't some kind of a inadvertent slip-up, but really the admission was in context and can't be explained away. But again, lead into it by saying the point of the quotation, then have the quotation, and then potentially reaffirm it or explain where it leads you and why. Footnotes should be used sparingly. The way I usually use them is to address things that aren't important but might confuse or distract the court. Bear in mind, footnotes are often not sufficient to preserve issues and avoid a waiver. Don't use them to try to evade page limits. Now, some people think that all citations should be in footnotes, and I don't agree with that. I actually attended a debate between Justice Scalia and Brian Gardner on the subject, and I came down on the Scalia side that I think it's nice to see the support for something without having to look down at the bottom of the page. But it can be an interesting writing tool. If you want to make your writing more forceful and improve the flow, you could consider doing a draft where you move the citations to footnotes, and it really makes it easier to see how the points are fitting together. Conclusions are underused, including, I admit, by me in a number of my documents, especially when I was coming up against a page limit. But if you can possibly free up the space, try to use the conclusion to summarize the issues in an interesting way. Remind the court if you have multiple grounds for a particular outcome, and clearly say what you want the court to do, including alternative remedies. as a final point, declarations can obviously be a really important tool in support of and opposition to motions. A lot of times they read just like the brief. Try to make the declaration stand out as a story being told by a witness. You can still use section titles and topic sentences, and should. Consider graphics, but see if you can write somewhat in the witness's voice. Develop a bit of a character for the witness. And when the witness's conduct is at issue, consider explaining why the witness acted as he or she did. Try to create a fuller picture of the person and an understanding of how the events came down from that person's perspective. So, in summary, always try to think like your audience. Try to allow enough time to reflect on and revise your writing. Never stop trying to improve the document. Be creative. Even see if you can have a little fun with the document and the project. Good luck.